Welcome back. Attorney Andrew Bethel here once again, not to talk about politics, but instead, let's bring this back to our core focus: estate planning and how to avoid unpleasant surprises for your loved ones. Today we're going to talk about a man who had a lot of fun, had a lot of kids, and had one that he didn't even know about make a claim on his estate after he died. So hit the like button, subscribe, share the video with that one family member who might just have more kids than they should, and let's dive in. In prior videos on this channel, I've discussed cases where a stepchild has successfully claimed an inheritance right as a natural heir, a status typically reserved only for blood-related and adopted children, as well as a case where a child born out of wedlock's inheritance claim was challenged. However, today we have a case where a father had many children, left all of his estate to just a select few, made no mention of his other children in his documents, and a child he didn't even know he had popped up to make a claim on his estate. Our story begins with Benjamin C. Williams, who we'll call Ben from here on out. Ben had a lot of fun in the 1960s, as one does, and fathered 5 children before moving to California, and of course, not all with the same woman. Ben did settle down a bit when he got to California. He got married and had 2 more children. That brought his total up to 7. However, Ben knew about all these children except one, Carla Montgomery. In 1999, while living in California, Ben established a trust with only named beneficiaries being his 2 youngest children. The trust contained no general disinheritance clause, as in it only devised everything to the 2 youngest children and didn't mention that he didn't want anything to go to any other children. And in fact, didn't even mention the other children that he was aware of in the first place. 10 years later, in 2019, Carla's daughter did some DNA testing and finds out that her mother, Carla, had siblings out there, and they got into contact with one of the children Ben had in his California marriage. They arrange a family get-together where Carla meets her other half-siblings for the first time and learns of Ben's recent passing. A couple months later, Carla receives the required notice of the existence of Ben's trust and promptly files in probate court to receive a share of the estate under California Probate Code Section 21622, which we'll talk about in a bit. Years later, they finally have a one-day trial where the judge finds against Carla, finding that she failed to even establish a case or cause of action. The court agreed with Ben's estate's argument that Carla failed to show that Ben did not provide for her solely because he was unaware of her birth. More specifically, the court found it credible that Ben was aware of yet failed to provide for his 4 other children, and accordingly found Ben's intent was to provide only for the 2 children of his marriage in his trust. Let's establish what the court ruled on this case before we talk about the rationale, what the probate code says about omitted children, and what we should do to plan around it in the future. If a child is born before signing testamentary instruments, a will or a trust, and they are omitted from the documents, then they are presumed to be an omitted heir and may be entitled to a portion of the estate. However, the court here ruled that to inherit a share of a parent's estate as an omitted child, the child must show that the sole reason for omission was that the testator was unaware of the child's birth. In this case, Ben provided for 2 of his children, but left nothing for the other 4 that he was aware of. Because Ben was aware of the existence of those other 4 children, the court found that him leaving them nothing was wholly intentional. Thus, because it stands to reason that he gave these 4 children nothing on purpose, that his true intent was for the children of his marriage to be the only children to receive anything. Because Ben knew about these other children and omitted them, Carla receives nothing. Had Ben not known about these other 4 children, just like Carla, my bet is that Carla would have prevailed here, along with those other half-siblings. And Ben's estate would have just been split 7 ways. But what if Ben had included the 4 but disinherited them, leaving Carla as the only omitted child, and there wasn't a general disinheritance clause disinheriting any other children? Well, I think Carla would stand a better chance of prevailing, but still likely lose that challenge as well. Basically, Ben didn't want anyone else to get anything anyway, whether he knew about them or not. He only wanted the children of his marriage to inherit from him, and that's it. Let's briefly discuss the court's rationale and what the law says about omitted children. Firstly, California Probate Code Section 21622 states, if at the time of the execution of all the decedent's testamentary instruments, effective at the time of the decedent's death, the decedent failed to provide for a living child solely because the decedent was unaware of the birth of the child shall receive a share of the estate. This section was the basis of Carla's claim on Ben's estate. However, as discussed, the court slaps this argument down, reasoning that due to those key words, solely because the law requires that in order to prevail, the only reason for the omission of the child can be because the decedent didn't know about them. Yes, Ben didn't know about Carla's existence. However, because he was aware of the other children that he also omitted, we can infer that Ben's intent was to exclude all of his children from his estate except for the 2 he specifically provided for. Ben's intent not to provide for the known children will extend to any unknown children, in this case, Carla. The court goes on, in this case, to differentiate what should happen where an omitted child is born before or after the execution of testamentary instruments. Previously, it didn't matter whether the child was born before or after the execution of the documents. If they were omitted, then they could make a claim. However, that law was changed, and now for children born after execution of a will or trust, their omission is presumed to be inadvertent, and thus they can receive their share of the estate unless the intent to omit them is apparent in the will or trust, substantially all the estate is devised to the omitted child's other parent, or the omitted child was provided for through some outside gift in lieu of a gift through a will or trust. Additionally, now for children born before the execution of a will or trust, their omission is presumed to have been done intentionally, unless, of course, the sole reason for the omission was because the decedent did not know the child existed in the first place or thought they were dead. And this is the case that Carla found herself in here. So what do we do now? This comes from a case, Estate of Benjamin C. Williams, that was published very recently, August of this year. So what do we do with this information? Well, I think we don't have to change that much in what we do. Of course, the first thing is to simply make sure we acknowledge the existence of any and all children that are out there, regardless of whether we want them to inherit from us or not. Beyond that, I think we can cover our bases by simply having a general disinheritance clause in the will or trust that simply makes it explicit that only the parties identified in the document are to be considered as the beneficiaries of your estate. Very simply in practice though, I'm sure we'll see fights like this from now until the end of time. But now I want to know, what do you think? Do you agree with the court's ruling, or do you think they should have allowed Carla to inherit since Ben didn't even know she existed? Or do you need to take a second look at your will or trust? Let me know in the comments below. For now, thank you for watching. Like, subscribe, share the video with your kids, intentionally omitted or otherwise. I'm attorney Andrew Bethel, and I'll see you at our next meeting.